Justice Kagan?
Mr. Agarwal, it seemed to me that when you were talking to Justice Alito, you had more to say about this question of comparative risks and how we should balance the two kinds of risks and what we should be thinking about now. So I wanted to give you a chance to say that. But and within whatever you want to say about that topic, I was wondering if you could comment. A lot of these hypotheticals have been about, what if Congress structured an independent agency like this or like that? I mean, most of these independent agencies, Justice Sotomayor is right that the CFPB was anomalous in this respect, but basically, like, the vast majority of them all use the exact same structure, or if not exact, near exact same structure. There are little variations, but they're all set up with bipartisanship. They're all set up with a chair that does have some greater control and that is more controllable by the president. They're all basically set up the same way. So all of these hypotheticals about what if Congress did this, I'm wondering if you could comment in your discussion of comparative risks about how we actually why it is that we actually have just never seen that.
I think it's because the political branches have learned from experience, and experience is the great teacher. There's an insightful discussion of the history and tradition surrounding traditional independent agencies and the separate opinion in the PHH case that has been cited extensively by the parties, and that explains that the structure that the political branches have come up with honors and gives effect to our constitutional values, as we explain on the very first page of our brief. We think that the political branches have done a good job of learning.
The political branch is Congress, which is made up of both Democrats and Republicans, who are aware that neither Democrats nor Republicans will control the government forever, and are structuring these systems with that in mind.
I think that is exactly right, Justice Kagan, that there's an appreciation and an understanding that folks in power today may not be in power tomorrow, and you want a structure that will be able to withstand the test of time. The other kind of interesting thing about this is that it's not just Congress. It's Congress acting together with the president every single time. In the case of the FTC Act, the act has been amended time and time and time again since this court's decision in Humphrey's executor. Presidents are signing all of those bills into law. They are supporting the FTC in a myriad of ways. They too have read the vesting clause of Article 2, and they too believe in preserving executive power. It is simply implausible to say that presidents have been supporting these traditional independent agencies now for more than a century and a half, and even from the first Congress, George Washington signing into law the Sinking Fund Commission, the Revolutionary War Debts Commission, the Mint Commission. It is absolutely implausible to say for the entirety of American history, presidents of the United States have been complicit in giving up a vital executive power that is, according to petitioners, indispensable to their constitutional duty. The better answer by far is to say that presidents have understood and appreciated that vital interests of the American people can be served by having constraints on the exercise of power. That is a really important part of our constitutional tradition, and that is what petitioners are putting at risk.
You mentioned some of the early history, and I think I want to give you a little bit of a chance to talk about that because we haven't. When I was a young lawyer and this unitary executive theory really got its start and got its legs, there was a pretty simple version of the history, and that drove a lot of the early discussion of the unitary executive, what was wrong with Humphrey's executor. What have the historians been telling us more recently about that sort of early understanding of the history? And bring us up to date here a little bit about where the history is with respect to these issues.
There's an insightful discussion of this in an essay authored by Professor Nelson that we have cited in our brief and that cites recent historical scholarship. And there is also many amicus briefs that have been submitted in this case, which basically affirm that there is a rich body of recent, including post-CLA law historical scholarship that supports the conclusion that the history surrounding this issue is at a minimum contestable. And that there is a whole lot of history, actually, that supports the proposition that the first president of the United States and the first Congress did not believe that the president always and everywhere had to have an absolute, illimitable, indefeasible power to fire every single head of any kind of commission exercising any significant governmental authority. We know that from the first Congress and the Sinking Fund Commission, the Revolutionary War Debt Commission, the Mint Commission, and I think there are some 10 other commissions, for example, that are discussed in Professor Norse's amicus brief, just by way of example. I think that's another virtue of our position, that we're asking the court to give effect not just to the decision of 1789, but also to the decision of 1790. The other side's not doing that. They want you to give a maximalist interpretation to, for example, the decision of 1789, which we agree settled the question of whether the Senate should be able to interfere with presidential removals. But everything else, as Professor Nelson explains, as many other scholars have ably explained, is highly contestable at a minimum. There's actually a lot of historical evidence that goes the other way. That is all the more reason for this court to be cautious in developing heavy-handed constitutional rules that, one, don't have a clear basis in constitutional text. We absolutely accept this court's precedents that interpret the vesting clause of Article 2 to establish a general default presidential removal power, but it cannot be said the constitutional text clearly delineates the boundaries between the president's power and Congress's power with respect to removal. Then when you add to that a growing body of historical scholarship indicating that original understanding from the time of the first Congress and the first president was that significant governmental authority absolutely could be vested in commissions that were not subject to plenary presidential control, that every single member was not subject to presidential control. And in fact, in a lot of respects, as the scholars have explained, those early commissions were actually substantially more independent than modern-day administrative agencies. For some of them, the president couldn't even appoint. He couldn't even decide who would be on the commission, as, for example, with respect to the Sinking Fund Commission, where you had the Chief Justice and the Vice President were, by operation of law, installed on those commissions. So those commissions were, in a lot of respects, much more independent than modern-day traditional independent agencies.